I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I will be bringing you compilation number 114, and we will be in 4 different judges' courtrooms on today. Don't forget to like, comment, share, subscribe. It is always helpful to the channel and helpful with the YouTube algorithm. Also, there will be no commentary added to this compilation. Chapters will be added for your convenience. And also, don't forget to go to our playlist and check out our compilation list with all of our different compilation videos in there. Our compilation playlist, over 100 videos, and I'm sure it's many proceedings that you guys have never seen. So don't forget to go to our channel, click on playlist, and you will see the drop down menu and you will find the compilation videos playlist. And I'm sure there's something in there that you have never seen. Now, let me give you the rundown on the judges' courtrooms that we're going to be in on today. First, we're going to be in the courtroom of Judge Devin Collier out of the state of Florida. Second, we will be in the courtroom of Judge Arianne Slay out of the state of Michigan. Third, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas. And last but not least, we will be in the courtroom of Judge Joe Lee, also out of the state of Kansas. Listen, as always, this is a very interesting compilation full of interesting arguments and back and forths. So hold on to your hat, buckle up, and let's go ahead and jump into number 114.
Say Tavius Morris.
I'll come to the jail and talk to you.
Good morning.
Good morning, sir.
How you doing this morning?
I'm well. How are you?
Fine.
Morris had previously, there was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
All right, I'm going to appoint the law officer here, Mark Sims, to represent you in the 24 case.
I go state this to the court.
You raise your right hand and
Yes.
now that Mr. Hill is representing you, you probably want to talk to Mr. Hill before you say anything. We're recording this proceeding, so anything you say may be used against you. But I'm listening to whatever you want me to consider.
I'm not real sure what Mr. Morris is trying to claim in that writing right there. Said he's not a citizen and something about a secured.
My name is Alize Morris, a secure party creditor under the UCC-1 filed in Florida. American national being held in custody in Gulf County, which is not a 14th Amendment citizen of the United States. Not a record. So documentation, which is official records. To state it, I'm the agent of the said principal.
Who wrote that for you?
I did.
Why do you need to read it if you know what you're talking about?
This memory.
Okay. Tell me what the 14th Amendment says.
That you were considered a slave under the 14th Amendment.
That who's considered a slave? I'm not a slave.
No, the incarcerated person. This if you commit a crime.
Okay. Doesn't say if you commit a crime.
Or yeah.
That's not what it reads.
I got the 14th Amendment really wasn't in the book.
What book?
The book that we had in the back.
What book do you have in the back?
It's a law book.
What law book is it?
Florida statute book. Yes.
So the 14th Amendment isn't in the Florida statutes? That's because it's an amendment to the U.S. Constitution.
Mm-hmm.
So you don't know what the 14th Amendment reads?
The 14th Amendment reads not off on the top. Not off.
Okay.
That's why I written.
What else do you want me to consider?
that I'm a secure party creditor under the UCC 1.
Tell me what the UCC 1 reads.
I wish I had my documentation in front of me to present it all the way. I wish I had someone here that was supposed to be here so I can have it.
I asked you who wrote that for you. You said you did.
I wrote it. Yes.
So do you know what you're talking about?
Yes, sir.
All right, so tell me what the UCC 1 reads.
It's the uniform commercial code filed with the Secretary of State or within the entities under the contract with the Secretary of the State to maintain uniform commercial code records and database of judgment liens maintained by the Secretary of State.
Now tell me what UCC 1 reads.
It's a statement and it's a financial.
You don't know what the UCC 1 reads, do you?
Not on top.
You're not prepared. You're not prepared this morning with your sovereign citizen argument. You needed some additional time to prepare.
Yes, sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
I would ask that he's got 2 cases. I know one we've got already got the discovery on that I need to go meet with him at the jail and go over. Being at the jail, I mean, I can find time between now and May 9th to go to the jail and take care of that.
All right, Mr. Morrison, you come back. Usually when sovereign citizens come in the courtroom, at least they can recite from memory a lot of the stuff they travel under. So next time you want to come with your sovereign citizen argument, be prepared, okay? I'll listen to you, but be prepared.
Yes.
But you're not doing justice to your fellow traveling nationals who consider themselves sovereign citizens if you're not prepared to even articulate what the argument is, all right?
Yes, sir.
All right, we'll see you May 9th at 1:30.
Today.
Be prepared next time, all right?
Yes, sir.
It should have a constitution in the back so you can read the 14th Amendment and be able to tell me what it reads. And
What it says right here. What it states.
we're gonna May 9th at 1:30.
Machine into a contract.
That's not a contract. That's giving you notice that you're
Yes,
gonna
sir.
come back.
Just making sure.
You're fine. I'm not going to query you about what a contract is, but we'll talk about whatever you want me to consider next time. Take care. Say Tavius Morris.
I'll come to the jail and talk to you.
Good morning.
Good morning, sir.
How you doing this morning?
I'm well. How are you?
Fine.
Morris had previously, there was one case that I was already representing him on. I don't know that we ever got one on this most recent charge. Okay.
Let me see.
Mr. Morris, I know Mr. Hill was representing you in the 23-174 case. You're here for an arraignment on the 24 CF49 case. Has your financial circumstances changed?
No, sir.
All right, I'm going to appoint the law officer here, Mark Sims, to represent you in the 24 case.
I go state this to the court.
You raise your right hand and
Yes.
now that Mr. Hill is representing you, you probably want to talk to Mr. Hill before you say anything. We're recording this proceeding, so anything you say may be used against you. But I'm listening to whatever you want me to consider.
I'm not real sure what Mr. Morris is trying to claim in that writing right there. Said he's not a citizen and something about a secured.
My name is Alize Morris, a secure party creditor under the UCC 1 filed in Florida. American national being held in custody in Gulf County, which is not a 14th Amendment citizen of the United States. Not a record. So documentation, which is official records. To state it, I'm the agent of the said principal.
Who wrote that for you?
I did.
Why do you need to read it if you know what you're talking about?
This memory
Okay. Tell me what the 14th Amendment says.
that you were considered a slave under the 14th Amendment.
That who's considered a slave? I'm not a slave.
No, the incarcerated person. This if you commit a crime
Okay. Doesn't say if you commit a crime.
or yeah.
That's not what it reads.
I got the 14th Amendment really wasn't in the The book,
What
Right.
book?
the book that we have in the back,
What book do you have in the back?
it's a law book,
What law book is it?
Florida statute book. Yes.
So the 14th Amendment isn't in the Florida statutes? That's
I
because
was
it's an amendment to the US
It's-
Constitution.
Mhm.
So you don't know what the 14th Amendment reads.
The 14th Amendment reads not off on the top, not off.
Okay.
That's
What else
why
do
I
you-
written
What else do you want me to consider?
that I'm a secure party creditor under the UCC 1.
Tell me what the UCC 1 reads.
I wish I had my documentation on in front of me to present it all the way. I wish I had someone here that was supposed to be here so I can have it.
I asked you who wrote that for you. You said you did.
I wrote it. Yes.
So do you know what you're talking about?
Yes, sir.
All right, so tell me what the UCC 1 reads.
It's the Uniform Commercial Code filed with the Secretary of State or within the entities under the contract with the Secretary of the State to maintain uniform commercial code records and database of judgment liens maintained by the Secretary of State.
Now tell me what UCC 1 reads.
It's a statement and it's a financial.
You don't know what the
says-
UCC 1 reads, do you?
Not on top.
You're not
I
prepared
wish-
you're not prepared this morning with your sovereign citizen argument? You needed some
I need
additional
more-
time to
Yes,
prepare?
sir.
I'll give you some additional time to prepare your sovereign citizen argument. When do you want to come back?
I would ask that, he's got 2 cases. I know one we've got already got the discovery on that I need to go meet with him at the jail and go over. Being at the jail, I mean, I can find time between now and May 9th to go to the jail and take care of that.
All right, Mr. Morrison, you come back. Usually when sovereign citizens come in the courtroom, at least they can recite from memory a lot of the stuff they travel under. So next time you want to come with your sovereign citizen argument, be prepared, okay? I'll listen to you, but be prepared.
Yes.
But you're not doing justice to your fellow traveling nationals who consider themselves sovereign citizens if you're not prepared to even articulate what the argument is, all right?
Yes, sir.
All right, we'll see you May 9th at
supposed to be
1:30.
Today.
Be prepared next time, all right?
Yes, sir.
It should have a constitution in the back so you can read the 14th Amendment and be able to tell me what it reads. And
What it says right here. What is state?
we're gonna, May 9th at 1:30.
Machine into a contract.
That's not a contract. That's giving you notice that you're
Yes,
gonna
sir.
come back.
Just making sure.
You're fine. I'm not going to query you about what a contract is, but we'll talk about whatever you want me to consider next time. Take care.
Numbers 31 and 32, People versus Taft Lewis, 16432 FH.
Well, this was adjourned from last week. So here we are.
Here we are. You have the opportunity to speak to Mr. Lewis.
Not really directly to Mr. Lewis. We did mention to Mr. Judge Conlon that I was thinking, based on the fact that he's been struggling financially, if the court would be willing to waive the waivable fees, that would leave him a $73 mandatory balance. We never really got that far. So
Okay. All right, I see there's a range on bench warrant. He'll owe 73.
yes, that's correct.
What's the amount of the waivable?
He owes $2,045.80. Of that total, $73 is mandatory.
Okay.
And he's paid $125 so far.
Mr. Attorney General, what do you have to say?
Well, I guess I'm not entirely clear on the basis of the violation. I don't have, I'm not sure I've received documents regarding that. With respect to the underlying child support case, Mr. Lewis currently owes $21,415.70, and he has a current obligation of $66 a month. That's 66. And his last payment was in August of 2022. Further, I also am not sure if Mr. Lewis has any representation in this matter or not.
No, I'll be representing myself.
Oh, okay.
I have PD written down here, but
I did try and see him this morning, Your Honor, but he said he's representing himself.
Yes, ma'am.
oh, okay. So I'm sorry, I thought Mr. Gaddy was here on this. Sorry. I
Two
can-
issues,
Okay.
the collections issue and then the probation violation.
Okay. So as to the collection issue, I can waive the waivable amounts
And Mr. Petherbridge, if you submit an order for that, leave
Will
it
do, Your Honor.
balance at 73, you said?
Yes, that's correct.
Okay. And Mr. Lewis.
Can I speak now, Your Honor?
Yep, just a minute.
No problem.
Okay. Mr. Lewis, pursuant to Court Rule 6005, you have the right to the assistance of an attorney. So I can read you this section here if you're interested in
No, ma'am.
representing yourself.
Yes, I am, ma'am.
You are interested in representing yourself.
Yes, I've been
Okay, hold
representing
on.
myself since 2010, ma'am.
Okay, well, so then you've probably heard this a time or two, but we're supposed to read it to you every single time you come to court.
No problem.
Okay, so hold on just one second. Says here under subsection D, the court may, and this is in the initial waiver, so I'm assuming some other judge did this for you, but if not, here it goes. You are being advised that of the charge that you have in front of you, the violation of probation for which you have a VOP that is pending, alleges that you violated condition number 3 about making a truthful report to your probation officer monthly, as that they required, and that you failed to report on 1/26/23, and that you on 1/27/23 a call was placed to you and contact was made. You said you were going to turn yourself in on the warrant. The potential penalty in this case is up to 5 years and or $5,000. And I will read this verbatim. Advising the defendant of the charge, the maximum possible prison sentence for the offense, any mandatory minimum required by law, and the risk involving self-representation. In addition to that, I will offer you the opportunity to consult with a lawyer that you can retain of your choosing. Currently you're in custody, so I'd also appoint the public defender's office if you wanted assistance. That's my understanding that you are not interested.
No assistance needed, Your Honor.
Okay. This is your choice. All right, so how are we proceeding with the violation of probation?
Your Honor, I don't respect the reason I'm here today, but I will not disrespect your court because of others' egregious actions towards me. This is our first time meeting, and I plan on it being our last. Before Mr. Breckenbridge left, I would have liked to address the whole panel. So that I had just a few questions for him to set precedent so that everyone's stance could be evident and clear and no misinterpretations. But I see Mr. Breckenbridge tucked tail and ran.
Well, we're making a recording and he's still here. He just was out of the camera view.
Great. Mr. Breckenbridge, can you please state your full name and title for the record?
Scott.
Mr. Lewis, this is not your hearing.
I can't address the panel.
There's no panel.
You have the probation officer, you have the court fines and fee officer, and you have the assistant.
And everyone put their appearances on the record. So we're going to move it along.
No problem. I can get right to it. That is fine.
All right.
The law is my protection, and I shall find remedy in it. Before we begin this process, I would like to address the court. In addressing the court, I would like to fully read and completely express all information today without interruption. I have two questions for the court. First question is, are all laws commercial? Second question.
Mr. Lewis.
Yes, ma'am.
We have a violation of probation in front of you. I understand that you have been arraigned on the violation of probation. And because you are decided that you want to act as your own counsel, I will hold you to the same standards as I would any other defense counsel in this same procedure and within the same case. So as to the violation of probation, you can accept responsibility by pleading guilty to the violation or no contest. You can set this matter for a hearing in which we go forward, but this is not your hearing to run. Do you understand?
Yes, ma'am. I just wanted to address the court and put on record some very variable value information. And by
asking me questions is not putting information that you have on the record.
yes, ma'am. I won't ask any more questions. Can I finish my statement? I have no more questions.
My question for you is, how are we proceeding with the hearing today? Are we proceeding with an acceptance, or are we proceeding that we need to set this matter for hearing?
Ma'am, this is not even a hearing that we should be having. If I could finish my statement, you could see that unless the AG has certain information, this is totally in violation and I'm not able to express myself. Like I said, I have no more questions. I just would like to read the information I have, and then they can go which direction they want to after the information has been expressed, ma'am.
Okay, tell me if you feel like the petition for your violation of probation is wanton in some regard.
It is not wanted at all, Your Honor. I shouldn't be.
It's not wanton?
I shouldn't be.
So you believe that it's accurate?
No, I believe it's inaccurate. I believe me being on probation is inaccurate.
Okay. Quickly, Mr. Taft Lewis.
I can finish. Thank you. I am the de jure. I am not an imbecile in law. I do not surrender my inalienable rights for any civil liberties. I am a five-fifths realized being and not a three-fifths Dred Scott compromised imbecile in law. I'm here today for the non-payment of what is commonly known as child support. For the record, there's no such thing as child support. The reason I'm here today is because you're trying to enforce a contract/agreement by forcing me or compelling me to be a surety for
Mr. Lewis, are you telling me that you're a sovereign citizen and you do not believe that the orders of the court apply to you?
No, ma'am, I'm not sovereign at all. I'm just speaking, I'm just expressing why.
That's what you just said.
I said I'm a five-fifths realized being, ma'am.
Okay.
That's not.
So these are, I need you, if you can't answer my question, we're gonna adjourn this until you can get a hearing, and I'm gonna appoint standby counsel of the public defender.
I don't want counsel, ma'am. I just want to finish.
I understand that. So what I want you to do, and you don't have to have Mr. Gaddy right next to you during your event, but your hearing for next week. But what I want you to do is talk to him about your available option, because what's very clear to me is that you're not listening to the questions that are being posed to the court. Right? I say, are we having a hearing or are you accepting responsibility? I need an answer to that before we can go forward. You making a statement isn't evidence. That's not evidence, Mr. Lewis. And because you want to represent yourself, you're going to be held to the same standard as if you were a defense attorney appearing in front of this court. You can change your mind about that and have Mr. Gaddy represent you.
No, I don't want any.
But in the meantime, I'd like for you to talk to him in the next week so that you guys can discuss what the proper way is to go about dealing with the court. Because as of right now, you're not following the proper criminal procedure. You don't get to just make statements. There's an order to things. So you can find that out for Mr. Gaddy. This case is adjourned until next week. We'll see you back on the 6th. Or exactly, Ms. Armstrong, does that give you enough time, or do you need to put it up 2 weeks?
Be released.
Oh, sorry, Mr. Attorney General, does that give you enough time to do a writ, or do you need more time than that?
Judge, our office will request 2 weeks, just to ensure we have time.
We'll put it up 2 weeks.
Am I being remanded to jail, ma'am, or am I free to be released and come back in? Because I came in on my own accords, ma'am. I have no problem with coming back. Whatever day.
I'd like to make a bond motion, I'll hear that.
Yes, I would.
First, I'll put the recommendation from probation on the record.
Thank you.
The recommendation is for Mr. Lewis to serve 4 days in jail with 4 days credit. And to report to Agent Priest, to report to probation on March 2nd in the office. Your Honor, I'd also like to make note that I have a note here that indicates. Your Honor, may we approach?
Yeah. I'm sorry, ladies and gentlemen, for those of you, we need to have a private conversation because we have Mr. Attorney General is not here in person. We have to clear the courtroom. That prosecutors. Okay, Mr. Taft Lewis, you got additional information. If you wanted to see me, there's a different way to do that. If you have a motion, or part of that is by working with an attorney who knows how to navigate the procedures of the court. Again, your choice not to use an attorney. I still have the standby counsel for the public defender should you choose to avail yourself of their decades of legal knowledge that might help you navigate this process.
Ma'am, I thought this was the hearing. I didn't know it was.
Pardon?
I thought this was the hearing because last week I could not speak also because he said it was your case and I would be able to have my turn to speak when I was in front of you. Now I'm in front of you and you're telling me this isn't the hearing also. So I didn't know how you guys were going to proceed. I just want to be heard on what information I have. Like I said before, I asked for this warrant so that I could get in front of you, so that I could say this information to see which way.
And Mr. Taft-Lewis, that's exactly what I'm saying, is that you had used the assistance of the public defender's office or your attorney who assisted you at the time of your case, you wouldn't have had to violate your probation to get in front of this court. I don't believe that you are a flight risk. I think you just made poor decisions. So I am going to release you, but you're to respond here in person, which is March 6th.
No problem.
On Monday at 1:30, and that is the date and time set for your hearing.
Yes, ma'am.
At that time, I would expect you to follow the proper procedure that any other criminal defense attorney would be held to the same standard. You still have the public defender at your disposal if you choose to consult with them.
No problem.
Could you also order him to report in person to probation office on?
You'll have to report to probation tomorrow. I'm sorry, March 2nd.
Yes.
You'll report to probation on March 2nd to meet with your agent.
Which agent is that? Is that Agent Moses, Agent Miller, or Agent Priest?
Agent Priest.
No problem.
Your Honor, if I could ask Mr. Lewis to contact my office and give us the, address and phone number.
Did you hear that, Mr. Lewis? The public defender is availing themselves to you.
I have no comment on that, but yes, I did hear him, ma'am.
I'm releasing you on PR.
Much appreciated, ma'am.
Okay, we will see you back here.
On all warrants, I had 3 warrants, one from the court fees and fines, I had one from FOC, and one from the violation of probation. Is that all warrants? I'll be released on PR?
Yes, and yes.
Much appreciated, ma'am. I will see you March 6th at 9 a.m.
See you then. It's 1:30 p.m.
March 6th.
Be there at
March 6th.
Yes, March 6th.
Okay. All right.
Number 33, People versus Hillary Marshall, 22321 FH.
We are on the record in 2024 TR 617. Sir, you may need to scoot over a little bit to be picked up by that microphone. I'm not sure, but sometimes you have to be in the middle with it. Marianne Shirley appears for the state. Are you Abel Estrada Jr., sir?
Yes, if I may, can I make a statement?
No, not yet. Okay, sir, you are charged in count 1 with on or about the 21st day of August, 2024 in Greenwood County, state of Kansas. Then and there, contrary to the statutes of the state of Kansas, unlawfully operating a vehicle, to wit, a 2011 GMC Acadia, upon a highway which does not have the signed license plate. I think they mean that the vehicle didn't, not the highway, but your vehicle did not have the assigned license plate properly affixed to the rear of the vehicle, showing the current registered year. And this is an unclassified misdemeanor. It is punishable by up to $2,500 in fines and a possible sentence of up to 6 months, 30 days minimum, up to 6 months, although probation is usually granted. Now, sir, did I not just have you in municipal court recently on the same charge?
Yes, and I don't understand why am I seeing again, because that would be double jeopardy. I'm saying for the same,
Well, sir, you haven't been tried on it. You
I have,
had a first appearance on it. And
I have,
apparently the city prosecutor must have dismissed it and refiled it over here for whatever reason, I know not. But as I recall, your plea was not guilty. Is that still your plea?
yes, but I'm here to make a separation between my name. My name is Abel Estrada with low caps. This name on the top, I don't know if you can see it. This name on the top is my straw man. I am the man, and this is the straw man. So if you're calling the straw man, I'm here to represent the straw man, but I'm Abel Estrada Junior, the man, the living man.
I'm calling the living man.
So
So are you going to have an attorney? Are you going to need to apply for court-appointed attorney, or will you be waiving your right and representing yourself?
no, of course, I wanted to have an attorney, but I still haven't not made my statement, which is,
Are you going to hire an attorney or apply for court-appointed?
I cannot afford an attorney, but I need to make my statement that
Let me get a few things worked out, sir. You're going to apply for an attorney, so you'll need to fill out an application for court-appointed attorney. And the deputy down there can give that to you. Make sure you fill that out and get that back to me before this hearing is over. Make sure you fill in all the blanks and you sign it and you date it where it says to, because I generally don't consider those if they're not thoroughly completed. And then you call back to my assistant, Missy, later in the week to see if one is appointed and who that will be. Do you need Missy's number, or did you take it down earlier from the other hearings?
no, I don't have.
All right. Missy, do you want to give him your number?
620-583-8155.
And then Missy, when is his next court date?
Well, I haven't explained my position.
Sir, we're not going to have a trial today. You're going to need to talk to your attorney before you have a trial. So Missy, when is his trial date?
I wanted to move.
Sir, please do not interrupt. Missy, when is his, and we won't set it directly for, do you want to set it directly for trial, or do you want to set it for a status so I can check in with you after you talk to your attorney?
I don't know what the status means.
Well, let's set it for a status, Missy, or control.
November 22nd at 10.
You, sir, will need to be back here by Zoom November 22nd at 10 a.m. Are you on bond? Let me check.
Why would I need a bond?
Complaint from the calls. There is no bond on the file, and it is an unclassified misdemeanor. So I'm not going to make you file a bond since it's an unclassified misdemeanor. If you fail to come to court, though, most likely a warrant would be issued anyway, and you'd be taken into custody. But as long as you come to court when you're told to, that's not going to be a problem. So you're going to call and get your attorney, or find out if you have an attorney.
I haven't given a chance to
You do not need a bond, and you have your court dates.
Number one, I want to move to a motion to dismiss this case because I didn't try for this, and I have the license plates, both license plates. I was not driving anything unlawful or illegal. I'm living in the private. I'm driving in the private, and so I want to move for dismissal with extreme prejudice. And also, I want to make sure that you understand that I want to keep all my constitutional rights. So far, my constitutional rights are being trampled over right now by yourself because you're not giving the chance to speak. I have not given the chance to speak. You're just going over and over, and I'm requesting that you remove this case because this is double jeopardy. I already appeared in court for this thing. I have not been given the opportunity to explain myself. I want to keep my rights, and I haven't been able to keep my rights. You yourself and the lady on the other side signed a oath of office to uphold the Constitution of the United States, and I'm not being given those rights right now, man. I respectfully request that you honor my rights. And I want to move for a complete dismissal because it's double jeopardy and I already appeared in court.
All right, well, I did give you the opportunity to speak. You were speaking, not I, not Miss Shirley. And so I gave you the chance to say what you want to. If you want to talk to your attorney can help you put together the motions that you've kind of implied, at least, if not outright said, you want to pursue. But we will take that up on the date that I gave you to reappear.
I'm sorry, I didn't, it's breaking up. You said you're gonna take what up to do what?
I can take up any motions that you want to file at a later date. With the next court date, we can revisit any motions or visit any motions you want me to consider.
I appreciate it, thank you. Being dragged down so much and I have a hard time moving around. As you can see, I'm disabled and I only come here once a week to the hospital to be treated, and all this court is putting a lot of stress, and I'm not able to heal properly. Why are we dragging it out so much, ma'am?
When did you get this disability? I don't remember you being unable to walk the last time I saw you.
I came in my bike is right here. I have it right here. I don't know if you can see it. But I normally use a walker in a wheelchair, but I'm using the other one because it's easier to carry in the car. It's what's it called? It's knee scooter. I have 2 amputations on my feet. So ambulation is very difficult. I'm having a lot of pain. In fact, I'm under medication right now. I don't have a clear mind, just so I can be here because it's too painful.
Well, that's why you need to call back here. You don't have to come in person. Call back here or have your wife or helper, whoever that is with you, call for you, and Missy can tell you if you qualify for an attorney and who that attorney will be and how you can get a hold of that attorney before your next court hearing. We did give you the date of that court hearing. You will need to be back here for that, but you can do that by Zoom. You don't have to even leave your home to do that, as long as you've got a clear signal that allows us to communicate. So you're always welcome to come down there to the courthouse like you're doing now, but you don't have to, as long as you can communicate by Zoom. And remind me, what town do you live in, sir? Are you from Kansas?
Yes, I'm in Howard. But even last night, when I got the letter from the sheriff, they brought it to me at 5 o'clock last night. I didn't even know.
All right, well.
So it wasn't improperly served. I got it like literally last night. I'm trying to get paperwork come in and I don't have the time. I don't have the ability to move that fast. And so
you were just complaining a moment ago that this case wasn't moving fast enough, that we were dragging it out. So there you go. Move too fast, you say.
Yes, but it's dragging on because it should be dismissed.
Judge, I need to withdraw from this case.
Your Honor, Mr. Estrada is filed pro se, I do believe. Well, I know it was pro se filing.
Well, I do notice he's taken a number of filings in his own right without going through counsel. Mr. Estrada, you come back to my recollection, we've met in city court, correct?
Yes.
And now this is that tag and suspended license?
No.
It's a tag issue, Your Honor.
Just the tag, Your Honor.
All right.
I believe Mr. Paul is requesting to withdraw based upon essentially a sovereign type citizen claim filed by Mr. Abel.
Well,
Mr. Estrada, excuse me.
And also there's been a total breakdown in communications, Judge. He files his own motions. I cannot represent him.
He's okay. All right, Mr. Estrada, you were appointed an attorney. Apparently at one point you wanted one, or maybe we gave you one and you didn't want one.
No, that's not it.
Excuse me?
I'm sorry, that's not it. He's not, Richard Paul is not seeking my interest. And I put everything in the affidavit. He's not representing me. He's actually judging me before, he's judging me before I even go into court. He's not listening to my paperwork. So he decided he doesn't want to represent me. So I still need to be represented.
Well, Mr. Paul, you're allowed to withdraw.
Thank you.
You're welcome. Is this the last case you have on the docket?
Until 11, Judge. I have an 11, so I'm just going to mute myself and.
That'd be fine. All right. Now, I think you are going to have the same problem with any other attorney that you had with Mr. Paul. Mr. Paul, from this court's experience over the years, is a very competent, diligent attorney. Now, sometimes attorneys have to tell you their opinion of what's going to happen. And you may or may not agree with their opinion, but you do still want an attorney.
I do. I do need an attorney because I don't know how to defend myself with this court. And also, I have a thread of the communications that you can see it. And I'm not getting represented correctly. I'm sure he's a competent attorney, but I proceeded to give all my information, all my laws, and he
All
doesn't.
of your what? Your laws?
The laws, the Constitution.
Your Honor,
So,
Your Honor, could I say something, please? Mr. Estrada, every attorney who the court can appoint to represent you, one, I don't want to see, and I'm sure the judge is the same way, I don't want to see any kind of communication thread between yourself and Mr. Paul, because there could be confidential, well, I'm sure there's confidential and privileged information within that, and you shouldn't be disclosing that to me. That's between you and any attorney you so choose to have represent you. But I believe most attorneys, or all attorneys that the court has available to appoint to you, they are sworn to uphold the Constitution of the United States and the state of Kansas, and not what you filed. That's the attorneys didn't go to your law school, which is kind of what you've set forth. So that's the issue the court's talking about when you're claiming a sovereign citizen. We don't have an attorney who's, I guess, registered to under your rules and laws as you see them. So that's the problem you're going to be running into as far as the attorneys the court has to appoint to you. I said that correctly, Your Honor.
thank you, Mr. Dean.
I like to say that I'm not a sovereign citizen. I'm just an American, and I'm just being constitutional, and I'm not doing anything. I'm not breaking any law.
Well, sir, you said the attorney wouldn't accept your laws or follow your laws.
No, that's not what I said. I
Okay,
said
what did you say? Because I thought you said you were trying to train him on the laws, in essence.
No, I don't. I'm just presenting the law to
All right.
him, and he doesn't even read my documents that I presented, which is the law.
Did you go to law school?
No, ma'am.
He did, you know that.
Yes, I understand, but he's not being constitutional. That's what I'm saying.
But you didn't go to law school, so are you sure you know what being constitutional involves? I mean, we all can read the Constitution and understand, yes, but there's a lot involved in interpreting that. Do you understand?
I understand what you're saying, ma'am. All I'm saying is that he's using case law, not constitutional law. And he didn't see all my paperwork. He just ignored it. He just blew through it and then gave me the wrong dates. I presented all the documents, and he didn't even look at it and ignored the paperwork.
All right, and let me ask you this. You are wanting a trial on this illegal display of a license plate or failure to display, right?
Well, no, I like to address. I'd like to first, if we possible, we can
a motion to dismiss with extreme
We're
prejudice.
not going to do that today. All right, I am going to one more time appoint you an attorney.
Your Honor, could I make a request to the court on this matter?
Sure.
This case carries a maximum sentence of 30 days. Doesn't even have an eligibility or requirement that he be provided an attorny.
Well,
I'm just.
There's
just saying,
potential jail time.
I would like to have, if the court wants, I understand if the court wants to appoint an attorney, absolutely. Don't dispute that. But under the circumstance of the defense that's wanting to be presented, I would ask the court to appoint somebody. I get Mr. McClendon still available.
That's just what I was thinking. He's here in town.
We set this next hearing, give sufficient time, perhaps 60 days, perhaps longer. And we just have it set for a bench trial. And if he doesn't want to cooperate with that attorney, the state would be asking for the court to proceed to trial, whether or not he can get along with the second one or not.
Well, it seems we're on the same page of thinking, counsel.
Mr. McClendon is in the waiting room.
Mr. McClendon.
I can bring him in.
Bring him in. You're in Howard. He's got an office here in Eureka.
Mr. Estrada believes in Wichita. You're wrong.
I thought, didn't you tell me you were in Howard?
I'm in Howard.
No, my mistake. I might have been on one of the notary stamps.
Well, you let Kit Collins in. Does Kit Collins want an appointment?
Oh, no, Judge, I just let all the 11 o'clocks in.
Okay. Mr. McClendon, could you join us for a moment? Were you in city court the night that Mr. Estrada, the gentleman under Motorola, had the tag violation?
Yes, Judge. You pointed me to his case briefly, and then Mr. Watson and I had a discussion and figured it would be more proper for a district court case.
Will you take the appointment if I give him back to you?
I guess, Judge.
All right. So you two have already met Mr. Estrada, right? The good news was he got it dismissed for you in city court, but the bad news is for you, it's back in district court. All right. So do you agree, Mr. McClendon, that we ought to just set it for bench trial, or maybe what do you want
set
to do?
bench trial, Judge. I'm familiar enough with the case.
Okay. He has filed some pro se motions. Okay, Missy, give me a trial date, please.
We can resolve those motions at trial, Your Honor.
Sure. I just want to let Mr. McClendon know.
How about January 3rd at 11?
January 3rd at 11.
Gordon Cooley. Case number is 24TR65. Are you Gordon Cooley? You'll need to unmute your screen, sir.
Yes, I am the man that is that person.
So you're Gordon Cooley?
Yep.
Very well. State appears by Jill Gillette, County Attorney. Mr. Cooley, there's been an amended complaint filed on, it looks like April 17th. You're charged with driving while suspended as a second offense for on or about March the 25th of 2024 in Elk County, Kansas. If indeed you have a prior conviction where this would be a second offense, that's a Class A misdemeanor. A Class A misdemeanor is punishable up to 1 year in the county jail and a fine not to exceed $2,500. Additionally, with a second offense for driving while suspended, there's a mandatory 5-day minimum sentence. However, a person can be placed on probation from that, but there is mandatory sentence that would have to be imposed. Do you understand what you're charged with?
No, I don't quite understand those no, I don't.
What's your question in regards to what you're charged with?
Well, I think this is a matter of a mistaken identity. My persons was never involved in anything. I'm carrying my property from point A to point B. There's no vested interest of the state to even stop me. I'm exercising my God-given constitutionally protected rights. And I stated that to the man acting as the police officer. I didn't present him with a
you
license.
are charged, sir. Hold on. You're charged with driving while suspended, a second offense. That would indicate to me that you've had a first offense.
No.
So have you been in court before on this type of charge?
Nope, not on driving while suspended. No, I have not.
All right. Well, that is what you're charged with. You don't have to agree with it. You can, certainly that is an issue at trial if you feel you have a defense. As with the others that I've explained, you have certain rights. You are charged with a misdemeanor, so you are entitled to be represented by a counsel. And if you wish to apply for court-appointed counsel, if you meet the financial guidelines, I would appoint one to represent you. You also have the right to represent yourself. You also have the right to have counsel of your own choosing at your own expense. So at this time, if you wish to have a trial, if you wish to speak with an attorney counsel, would he qualify under any programs you have since you charged this as a second offense?
No.
All right. So apparently diversion wouldn't be an option for you. So if you're wishing to have a trial or to speak with an attorney, your plea at this time should be not guilty. If you wish to plead guilty, then we'd proceed to sentencing. But based upon what you're telling me, those would be issues that could be addressed at trial. So at this time, how do you wish to plead?
I don't plan to plea. I guess I'll answer in affirmative that Demers is not acquiesced to quasi-jurisdiction.
If you're not going to enter a formal plea, you're standing mute, and I will enter a plea of not guilty on your behalf.
Okay, I exercise my right to trial by jury then. I'd like to face the man or the woman that claims I've done them harm or loss.
Mr. Cooley, if you wish to have a trial by jury.
I'm Gordy. I'm not Mr. Cooley. I'm Gordy. I'm a man. I'm not a person.
All right. Mr. Cooley.
Can I ask you a question, sir?
You need to be quiet for a moment. I'm going to explain what the situation is. You have the right to be represented by counsel. You entered a plea, refusing to enter a plea, which is fine. A person can stand mute, and I will set this matter for trial. If you wish to be or have a jury trial, you have the right to do so. However, you need to do that in the proper form. With a misdemeanor offense, you have to file a written motion for that request. Otherwise, it's set before the court. So you would need to do that in a timely way. If you're going to represent yourself, you would have to follow the rules as though you're an attorney. So all of those things would, most people don't have the training to where if they're going to do a jury trial, they're better off being represented by counsel. But that's a choice that you're going to have to make.
Okay, can I ask you a question?
Yes, you may.
Can there be a valid cause of action without an injured party?
Sir, that's not a valid question for what we're doing here today.
I've tried settling this matter in the private twice. If you have any papers in front of you with my signature on them, it's because that is what was required for me to get away from my captors. I don't understand what a man thinks that he has the authority to take another man and throw them in a box when they have harmed no man or woman, no claim has been brought against them.
You need to be quiet now. We're going to give you a court date, and you can advise me how you're going to proceed at that court date. If you're going to apply for a jury trial, then you'll need to make that application by that time. Otherwise, you'll be set for a bench trial. That's before the court. Sarah, could you give us a date, please?
What sort of time frame would you like, Judge? 30 minutes?
Approximately 30 days, 30 minutes would be fine.
We can do May 15th at 2:30.
at
Judge,
2:30.
I'm out that afternoon. We could do 11:30 if there's nothing else scheduled there.
We put that for a trial and for an hour, didn't we? So,
We could, if you only need 30 minutes, we could do the 11 to 12.
well, we said something at 10:30, I believe, or was it the 10 o'clock that was set for trial?
It was the 10:30 to 11:30 that was set.
Okay, let's set this at 11:30 for a pretrial. So, Mr. Cooley, you will need to appear at the courthouse in Howard. And if you're going to file a motion for a jury trial, you need to have done so by that time. If you're going to hire an attorney, you need to do that. If you're going to apply for an attorney, I would suggest that you do that as soon as possible, so that you can have counsel at that time.
Am I going to be able to face the man or the woman that has a claim before me, or are you going to discharge the matter? If there's not a man or a woman here, then this matter needs to be discharged.
Sir, I've heard these arguments before, and those are not legal arguments. Somebody's made these things.
I'm not a member of the legal society.
Sir,
Can you bring the law to the court, please? Can we bring the law to the court?
Mr. Cooley, stop interrupting. At your hearing, if you have motions that you wish to have heard, you can file them in advance. I would strongly recommend you be represented by counsel. But your court appearance is May 15th at 11:30, and you are to be here in person.
I will invoke my common law rights.
I'm not threatening you. Say one more word and that's 30 days. 30 days.